Yes, let's discuss that. Okay. All right, welcome everybody. My name is Tila Chalmers. I'm the CEO of the Alameda County Bar, which is where you are. And we are delighted to host this forum with the candidates for Judicial Seat 2, which is the only seat in Alameda County that is a contested seat in this election. Just a quick review for those of you who don't know. So judicial seats generally are up every 2 years. And if nobody files papers against a sitting judge, the sitting judge, you don't even see them on the ballot. But excuse me, sometimes seats are empty because judges retire, and that's where we are, how we got to where we are today, is that there's a seat empty as a result of a retirement. So we have 3 candidates here, Leela Zelani, Mark Fickus, and Elena Condis. And I want to also introduce you to our hosts for the evening, whatever you would call them. Question askers. Peter Shelton, who is a trust and estates lawyer in Berkeley, and Alice King, who is a family law attorney with an office in Contra Costa, right? And both of them serve on our board. Here's how it's going to go. And I want to really thank the League of Women Voters, without whom we could never do this. They are awesome.
Thank you for asking us to co-host.
They have materials right here, so don't miss that. In addition, so here's how this is going to work. We're going to start with a 1.5-minute opening statement from each candidate. And the league folks are going to help timing. They have little paddles. Can we see your paddle? No. Very nice.
And stop.
30 seconds and then stop.
And once the stop goes up, it just keeps moving, you stop.
Okay. And you know, they're called paddles for a reason. So just keep that in mind.
If you don't stop, you stop.
Exactly. We start with it. So, so they're going to start with an opening statement, and then we have questions. Each candidate will have a chance to answer the question. You'll get a whopping 1 minute, which is a lot more than you think it is, or it sounds like. And we'll sort of trade up who starts answering first. After we're done with that, we'll ask you all if you have any other questions, and you can stand up and ask your question. If I'm worried about the question, you may see me flying in front here saying, no, don't ask that, but I'm pretty sure you guys will be civil. And then at the end, each of them will have a 2-minute closing statement. When we're done, we're not going out this door, we're going out that door, and the candidates will be at tables. They'll have materials, you can talk to them, and so forth. There's food in the back, so please help yourself, and the water is over there. I want to call your attention to the fact that our restrooms on this floor are being renovated for like 5 months, but who's complaining? And so you should take a note of the code, and note that you need to take this elevator downstairs to get to the restroom. So it's a little bit of a journey. Okay, and with that, actually before I end, I just want to say one more thing. The Alameda County Bar is a membership association of attorneys. We also run several programs for the public, including our lawyer referral service, which is a number you can call if you need to find a lawyer who you want to be reassured is a good lawyer, strong in a particular area. So help us spread the word, if you will, about that service. Okay, and now, Peter and Alice, or candidates, you can direct the opening statement.
Well, why don't we just start with you, Willa? 1.5 minutes.
Hi, welcome this evening. I am Lila. I am the only candidate on this panel that's already actually a sitting judge. I've been a judge now for the last 15 years of my life, working for the Department of Industrial Relations, Division of Workers' Compensation. As a judge, I try cases on a regular basis. I listen to testimony. I issue rulings during testimony. I rule on objections. I review records. I judge credibility of witnesses, and at the end of the trial, I write a decision. As a judge, I've had the experience of having to litigate cases where only one side is represented. In the workers' compensation system, sometimes injured workers choose not to have an attorney represent them for one reason or other. And I have to manage to get through that case, making sure that the person who has no representation still has their due process rights recognized, but at the same time, also to make sure that the other side gets a fair share and they don't have to spend extra money than they would if they were opposing another counsel. And they've already started waving things at me, so I'm gonna wrap this up really fast. We'll get to talk a little bit more at the end of the evening anyways, a closing statement. But just keep that in mind that of the three of us, I'm the one with the most amount of experience when it actually comes to managing a courtroom. And I now have to stop.
Thank you. Mark?
Good afternoon, everyone. My name is Mark Fickus. I'm a partner with Canado, O'Toole, Fickus & Olson in San Francisco. I'd actually like to start with a story. A couple of months ago, I was sitting up in Lake County on a civil rights case I have, and there the courts are so small, the judges hear really every kind of case. And there was a really difficult divorce case going on that I had a chance to watch, and each party was unrepresented. They were clearly struggling to communicate with each other. And despite a docket of probably 100 cases that morning, I watched a judge patiently just sit and listen to what these people were, and not just reacting, actually listening to them, hearing their concerns, trying to understand their problem. And he, over the course of some time, was able to help them work through their problems. That's the kind of judge I want to be. The judge that understands that we have a lot of calendars, we've got a lot of problems on our docket, but we treat everyone who comes before us, irrespective of race, sexual orientation, gender expression or identity, or walks of life, with respect and dignity and courtesy. And I'd note that since I ran this race, I pulled out the canon of judicial ethics. A judge is supposed to perform their duties diligently, independently, and competently. And as we'll talk about a little bit more later, I have both the career experience and the temperament to be the kind of judge that will fulfill that's what is asked of us in the canon of judicial ethics. Thank you.
Elena?
Hi, thank you for being here. My name is Elena Holmes, and I've been an attorney in Alameda County for 26 years. My whole practice has been based in Alameda County. I've had an office in Oakland and Berkeley for the entire 26 years. And so what that has done is that has allowed me to really hone my skills in this county and work for the most vulnerable people in this county. My practice is in criminal defense, and I've been in the courts almost daily. And I've been in front of Judge Brosnahan, who is retiring after 40 years on the bench, throughout that 26 years. And because, I know, it's sad.
I didn't realize that's who was speaking.
And because she knows me, she knows my integrity, she knows my legal acumen, she has endorsed me out of the three of us to take her place. In addition to that, my work in the county has earned me the endorsement of 26 other judges, sitting judges in the county. Those aren't political connections. Those are people who know me, they know my work, and they also know that in addition to my experience, I bring welcome diversity to the bench. I am the first Latinx person to run for judge in Alameda County. There have only been 2 Latinas on the bench since the first one was appointed in 1997, and never more than that. We cannot continue to wait for somebody else to decide when and how many we get seats at the table that we get. So that is why I'm running, and I hope you'll echo your vote.
Thank you.
Okay. We're going to stagger our starts. Elena, and this will be for all 3 of you. Why do you want to be a judge? 1 minute.
I have been, as I mentioned, I've been in this county for 26 years. I understand the people in Alameda County because in the criminal defense arena, I'm in private practice, so I don't just work with the client, I work with their families. So I understand their struggles and the barriers to access to justice that they experience. And I want to be a hand in making things easier and to the extent that I can, to be on committees that I can, to enhance equal access to justice to all the people in the county. We've gone from regional courthouses to areas of law all over the county. There are real barriers to people when they show up to court and they're looking for justice. So that's what I want to know.
And Mark?
Yes, I've spent more than half of my career working in terms of doing trial work in the public interest. I started my career prosecuting sexual assault and domestic violence cases. I spent 8 years working for the federal government prosecuting corporate misdeeds, corruption, fraud, and scams that harm the most vulnerable among us, including elderly, the disabled, and such. I've also devoted my career to fighting for underdogs, whether it be elder abuse cases or civil rights cases for people who are victimized by government overreach. And so to me, having spent most of my life trying cases in the public interest, and having devoted most of my private life to the people of Alameda County through feeding people in the food bank to serving my community as a synagogue president, to me being a judge would be the ultimate expression of giving back to a community that's blessed me and my family here for the past 32 years.
Noah, why do you want to be a judge?
I don't know if you guys noticed, but you can tell the difference between the attorneys and the judges. They stand up and I kept on sitting. So I'm already a judge, so it's not that I want to be a judge because I already am that. What I want to be is a judge in the Superior Court. And why do I want to switch other than the fact that they make more money? Which is, of course, also a point behind this. But it's because I discovered that it's when you work on committees that you actually make a difference in the courthouse, right? So as a workers' compensation judge, I work on a lot of committees to try to make a difference to injured workers in the system. As a Superior Court judge, I hope to do the same thing, working on committees to improve what's going on with our restorative justice system, to work on the no cash bail system, to make sure that people actually have equal access to the courts because they don't because of finances, to help people in family courts, and also to come up with ways in which we can streamline cases so cases don't take 7 weeks to trial, but take 2 weeks to trial, so that everybody has more time and spends less money. That's why I want to be there, so I can start making a difference.
Second question. Alameda County has a broad range of racial, ethnic, LGBT, religious, and socioeconomic communities. What experience do you have that would give you the sensitivity or expose you to the different viewpoints and experiences of groups different from your own? And the first person to answer this question will be Mark.
Thank you. Well, first of all, if elected, I would be the only second openly gay man to serve as a Superior Court judge currently in Alameda County. And my commitment to the LGBT community goes back decades. One of the reasons Judge Tara Flanagan, an open lesbian judge, has endorsed me is she knows that I've been in a force for fighting for inclusion for LGBT lawyers since I was in law school when I joined Bailiff, an LGBT bar association. I'm now on the board of that association, so I work every day to fight for inclusion for LGBT people, queer people of color, and so on. In addition to that, I've been president of my synagogue and deeply involved in my community there. Some of the projects that we have been involved in over the years are helping to feed people who need food through the Alameda County Food Bank, through Henry Robinson House, through City Team, and through working with various other communities and other communities of faith. We've tried to reach out to all of the people of Alameda County so that no one feels excluded from a house of worship because of race, sexual orientation, or racial diversity.
Lila.
I'm an immigrant, as you can tell based on my accent. I immigrated from Hungary because my family was exiled from Hungary. He was a political prisoner. We moved from country to country until my dad still hasn't really settled down. So I lived in 3 different continents. While I lived in Australia, my mother worked in an Aborigine community for a medical center, and during school breaks I traveled with her, so I had an experience of understanding how Aborigines grew up. My father, being a sociologist, took me with him when he did his research in Hungary before we were exiled, and he was in the Roma community, so I had an understanding as to what it is to live in a Roma community. Overall, I understand what immigrants struggle with. In the workers' compensation system, I'm exposed to dealing with a lot of variety of different people, from highly educated to not educated whatsoever, different races. I'm very well equipped to deal with any of them. Thank you.
Elena.
Thank you. I'm a second-generation Mexican-American. I'm also a lesbian. I've been out since I was 17. I have, and you know, what I have learned in the criminal defense world is I've worked with a lot of different people, from very wealthy people to the people who are living on the streets. And also what I have learned as being a Latina in the court is what bias feels like. I have been stopped at the bar and had to show a judge my bar card when I stood up to represent a client because there are no Latinas in the courtroom. I have been pulled in to a courtroom because they were looking for the Spanish interpreter. So I get what it means to be other and to be looked at as other. And that's why diversity on the bench matters. So that when you look across and when somebody is looking at the judge and they see somebody who looks like them, who knows their family looks like them, it gives the court legitimacy. Thank you.
Sorry. So the next question is this. Every person comes in with some biases. What are yours and how do you intend to deal with them? We'll start with Lila.
You start with someone else on this one. I've been a judge for so long that I really don't look at anything that I do with a bias. Mr. Butler and I were talking, I've known him for about 20 years now overall. He knew me when I was representing injured workers and he knew me when I was representing the insurance companies. I look at cases really almost like just facts that get put into little puzzles. So I don't actually believe I have any biases anymore because I was trained over the last 15 years to really be unbiased, to really look at both sides and come up with something in the middle as what would work for resolving the case. That doesn't mean I always go to the middle. Sometimes I go for one side, sometimes I go for the other side. I learned over the time that rarely do I think about even the attorneys who are in front of me arguing the cases as to whether I like them or dislike them, because it just comes down to just looking at the facts, looking at the case, and just applying the law to the case. So having been trained that way for the last 15 years, I actually don't have a bias when it comes to the court system. I have biases about other things, but not the court system.
Thank you. Elena.
Thank you. We all have a bias, and that's just the human condition. And the thing to do is to learn the tools in order to neutralize it. And so that means when people are in front of you, to sort of take their positions and switch it, take their gender and switch it, take their race and switch it, and if to know whether you think the same, whether you feel the same way, if you've switched who they are, and then you can get down to what they're talking about. So bias is in all of us. And we should be honest about that and recognize it and do everything we can to eliminate that when it comes to litigants in the courtroom.
Mark?
Yeah, growing up as a grandchild of Holocaust survivors, I too understand what it means to be treated as other from just based on who you are or where you were born. And I've told people this story occasionally, but early in my career, I got called a faggot in a courtroom, and had a judge and lawyers really have nothing to say about it other than that was business as usual. So the point being is, we do all have our biases. I think growing up the way I did, I tried to not have explicit biases, but what I learned recently, I was teaching a legal aid group, and we did a whole training on implicit biases and all those biases that we're not aware of, and that's the catch. Is how do you deal with the biases you don't even know you have? And the way you kind of try to deal with that to be a fairer and a better person is you have to expose yourself and you have to educate yourself. You can't know about a bias if you don't know you have it, so you have to go out there, go to these places like Legal Aid, which does a lot of work on training about implicit and hidden biases, and educate yourself so that you can act in a more fair way.
Thank you. Next question. If you as a judge observe a party in your courtroom being poorly represented by an unprepared or ineffective attorney, how would you handle the situation? First person to answer is Elena.
I think that raises a couple of issues. One is interfering with the attorney-client relationship, and I think that a judge should take caution when they do that. I think that when somebody has, though, if they are clearly not being represented in a manner that is detrimental to them, then I think it's worthwhile to maybe pull the parties aside and question what they're doing. But if they are on a panel attorney, I think it's important to talk to the panel. But I would really caution interfering with the attorney-client relationship because it is sacred. I don't know all the facts of the case. and don't necessarily can assume that I know everything that was going on there.
Thank you. Mark?
Yeah, I agree with my opponent on this. The attorney-client relationship is usually one of choice, and I think stepping into the middle of it is ill-advised. I think for those of us who are in the courts a lot, it's not particularly fun to have judges trying to do our work for us. Having said that, I have been in situations, and I think I would act the same, where, for example, a lawyer was about to make in trial a tactical decision that was very dangerous in terms of potentially waiving attorney-client privilege in front of a jury. The judge called a sidebar, kind of brought us all there, and just said, do you understand the risks that are here? Are you prepared to take them? And if you're prepared to take them, that's your choice to make. I thought that was a very thoughtful way to address it, which is to not make a public spectacle out of it, not to berate the lawyer in front of a jury or in front of colleagues, but yet to call, when the representation is not just bad, but borderlines on dangerous, such as breaching a privilege or opening a door to something that could be really deleterious to the client, to call the person aside and educate them about it, or at least offer them, let them know what the consequences are.
I actually deal with this on a regular basis, not because the attorneys appear in front of me, don't know what they're doing, because they do, but workers' compensation attorneys handle large caseloads. Most applicants' attorneys representing injured workers handle about 400 cases at a time that are active cases. So they're not always going to be completely on top of the case that's in front of them. Same with defense attorneys representing insurance companies. Sometimes they get called the night before to appear at the hearing. What I do in these situations where I feel like there is something missing in the representation is I try to approach it by asking certain questions to lead the attorneys to think about what it is I'm trying to hint to them, to get an idea as to where they're supposed to go with their case. But other than that, I do agree with both Alan and Mark that you don't interfere with that relationship. People choose lawyers for a reason, and I'm not always right, and sometimes the attorney is trying to get a point across to me, which I may not think they're doing the right job, but maybe there is a point behind it, and I need to let them develop that.
What are your specific ideas about increasing alternative dispute resolution in any areas of the law? We're going to start with Mark.
Yeah, I have a lot of ideas about that. I do criminal and civil trials, but most of my civil clients are small businesses. And when you talk about a $300,000 or $400,000 trial, that really is make or break for most of the clients I have. And in Alameda County, for example, right now, regrettably, we have sometimes 2 to 3 departments in Alameda that try to do settlement cases. Judge Zeke is tremendous at it, Commissioner Rash, he's great at it. But sometimes there'll be 4 or 5 cases that they try to resolve in a morning. That's not doable unless you are superhuman, and while I think I might be a good judge, I don't think I'm superhuman. And so I do believe very much that we've starved our trial courts of funding for decades now, and I think one of the greatest things we can do to assure that justice is served in our civil cases in our county in particular is to devote a great deal more resources towards affordable forms of alternative dispute resolution, because not every litigant can go pay a JAMS retired judge $15,000 a day to resolve their dispute.
So, Lila.
One of the experiences I would bring to the Superior Court is the experience I have in workers' compensation, where we have 10 judges, each of us has scheduled with some kind of a calendar. And what we do amongst ourselves is we trade cases. So if I'm set for trial with on one case, then I trade with another judge. The other judge spends their time talking to them to try to settle the case, while at the same time I work on their case, trying to settle their case. So we do a lot of mediation to cut down on the amount of time that's actually spent on litigation. If we didn't do that, we tried every one of our cases, we'd be in a lot of trouble. That's, I think, an experience I could bring to the Superior Court to teach the judges as to how it is maybe they could have a different approach to how it is they're going about trying their cases, how it is they can work together as a team and try to figure out how to make it easier for parties to actually get their cases heard and finalized without having to actually go to a final decision.
And Elena.
Mediating and dispute resolution comes up all the time in criminal defense because 95% of cases don't go to trial. There is a lot of time in criminal defense spending in negotiations and trying to bring 2 parties together. And it is always better if both sides have buy-in for their ultimate result. And it helps things move along, because if you have we can't have everything going to trial. Most things do have to be mediated. And in the criminal realm, that's through alternative disputes, that's through alternative collaborative courts, mental health courts, so that those cases aren't even going through the system. And in the civil arena, all of those skills that I have learned in negotiating in criminal matters will help in getting civil litigants to resolve their disputes in civil litigation as well.
Question is, please give us an example of where you had to balance the law against what you felt was the right thing to do personally. And the first person to answer is Lila.
I've actually unfortunately had that a lot because I don't necessarily like our system of workers' compensation the way it's written, but I do have to apply the law the way it is written. Injured workers in the workers' compensation system are very restricted on how they get medical treatment provided to them. A lot of times their medical care is denied, and that no longer comes to me unless I can find a loophole in which I can find a way to take jurisdiction over the right to hear their disputes regarding medical care. And that's been weighing on me quite heavily over the last couple of years. When we went through complete reform under Governor Schwarzenegger, we had some new cases coming down, and the initial decisions were very negative from our appellate level, but I had to follow those decisions. I had no choice. As the years progressed, that has changed. So it's one of those things that you just have to do. It's your job as a trial judge. I do the best I can. I have to follow the law. I can't write decisions based on what I want the law to be. If that's what I wanted, I should become a legislator.
Elena.
Following the law is the right thing to do. And what a judge has, though, is judicial discretion. And to use that judicial discretion to make the law compassionate and work for everyone. So, for example, cash bail, there is this huge push for cash bail now, but judges can release people on their own recognizance now. We have the 8th Amendment now that allows for reasonable bail. We have a penal code section now that has a judge consider whether or not they are a flight risk or a danger to the community. So a judge can use their discretion and follow the law to get the just result. You don't have to pick and choose.
Mark, can I ask you to read the question back?
Sure. Please give us an example where you had to balance the law against what you felt was the right thing to do personally.
Well, I think I've been very blessed. I have never had to make a compromise between what my personal beliefs were and what I think the law allowed for in advocacy for my client. So I think I'm lucky that I've never had to kind of compromise that. And I guess I would have to say the closest I ever came with a client where I thought they were about to ask me to advocate for something I can't do, I told them I would have to resign, that I couldn't make that representation for them. So I think what I would say is if I were forced to make a choice between the two as an advocate, I would withdraw from a representation rather than advance a point that I thought was either unlawful, racist, unethical, or immoral.
Superior Court judges can be assigned to a wide array of civil, criminal, family, and juvenile cases. Please describe how your past experience qualifies you to best serve the public across so many areas of the law. And we'll start with you, Elena.
So the way Alameda County works is that they'll take somebody who comes in new to the bench and put them in an area that they don't know, an area of the law they don't know. That's going to happen for you, all three of us. What I have is a depth of knowledge of because I am in the trial court almost daily, of procedure, of court procedure, of Alameda County local rules, of jury trials, court trials, evidence, and all of the things that go in the daily workings of the court. That is what I bring to this, is just a depth of experience in Alameda County in the law. Knowing a bunch of different areas of the law, that isn't as important as actually knowing the law. Because at the end of the day, you're going to be using procedures, you're going to be interpreting the law, you're going to be reading case law, you're going to be using the same evidence code. Thank you.
Mark?
Yeah, thank you for that question. Actually, I believe that I bring the greatest professional diversity to the job, and that's one of the reasons I want it. I've prosecuted criminal cases, I've defended them. I've prosecuted civil enforcement cases for the SEC, and I've defended them. I have tried cases ranging from whistleblower retaliation cases to business disputes to insider trading cases and everything in between. I've actually handled in one way or another almost every case a judge is called to handle, with the exception of I have not done any family law divorce cases, and I have not done any probate work. But while judges are always going to be called to learn new areas of law, it is not just about reading a procedure book, and it is not just learning about new rules. We talked about alternative dispute resolution. How do you settle a civil case? You have to know what it's worth. How do you know what a civil case is worth? Having devoted a lot of years and experiences to figuring out what damages are, what they mean, how they're recoverable when they're not. And so I bring that breadth of experience to the job.
Thank you.
I'm gonna do what he did, because I totally forgot
Yes,
what the
of course.
question was, yeah.
Superior Court judges can be assigned to a variety of cases: civil, criminal, family, juvenile. Describe how your past experience qualifies you to best serve the public across so many areas of the law.
I disagree with Mark. I think I come with the best experience because I am a judge. And you can't discount 15 years of judicial experience as being nothing because he's litigated a lot of cases in a lot of different courtrooms. I give him a lot of credit for what he did. I give a lot of credit to Elena for what she did as well. But at the same time, I find that doing what I've done for the last 15 years, I'm going to go in there knowing what it is to be a judge. I'm not going to know every area of the law, but I went to law school, and hopefully they taught me how to interpret law, right? And since I've been a workers' compensation judge, the law has changed so many times. Every time we get a new governor, we have new law. Every time a new year comes along, our department sends us new regulations that I have to learn and apply. This year it was about this high. I haven't gone through all of the regulations. So I'm really well trained at how it is. I have to change my views, how I have to change my application of the law. And I know how to run a courtroom. I've been doing it for 15 years.
Next question. What is the appropriate conduct for a judge when in a hearing, a male attorney acts demeaning towards a female attorney, referring to her as, quote, the little lady? Mark, we'll start with you.
Well, you know, having had an experience that I talked about earlier of being called a rather unfortunate name in the middle of court, I think it is entirely appropriate for a judge to be, well, first of all, I don't think a judge should publicly humiliate anyone. So to reprimand them aggressively or in public, I think, is not the response. I think the response, using the example you used of a male attorney calling a female a little lady, I think to bring them into chambers or to take a recess immediately when that happens, to bring them into chambers both so that you don't have an ex parte communication, and to explain to litigants that demeaning, improper conduct of any kind, whether it's directed to race, gender, sexual orientation, religious belief, or anything, has no place in a court of law, and it cannot function in a court of law, and that won't be accepted in my courtroom.
Lillian.
I've actually dealt with that on a number of occasions, not specifically someone calling someone a little lady, but two people getting into each other and acting inappropriately, whether it's racial slurs that were being used or anything else. I did what Mark said. I did take them into my office, which is right behind my courtroom, and had a discussion with them. Workers' compensation is a very small community. We see each other day in, day out. You know all the attorneys. So it's really important for people to get along and not get caught up in name calling or belittling or any kind of innuendo. So it is not unusual for us to take someone back into our courtroom, sit them down, remind them what they're there for, remind them who they represent. The case is not about them, but their clients. And usually once you remind them that they're there to represent their clients, and by doing this, they're not doing that, they usually stop that behavior.
Elena.
So that was my experience with Judge Peggy Hora. I think it was somewhere in the late 90s. I was arguing a motion, and the guy next to me kept calling me the lady lawyer. And so Peggy Hora just said, look, you can't keep calling her the lady lawyer. She doesn't call you the guy lawyer. So I disagree with both of my opponents, because that is a learning moment for everyone in the courtroom. It doesn't have to be demeaning, it doesn't have to be disrespectful, but it is a moment to let everybody in there know that that is the place where everybody is treated the same, everybody is treated fairly, and nobody gets a pass. So I think it is an open court. It is in front of everybody, but done respectfully and kindly.
Please describe a courtroom situation that tested the limits of your patience. How did you respond? Lila, pick one.
I had this man that would come to my courtroom on a regular basis. He's no longer around. His name was Mr. Baker, and he would always show up. And I say, okay, Mr. Baker, you ready to go to trial today? And he'd say, yes, I am. Like, okay, go ahead, take a seat, Mr. Baker. And he'd stand up and say, you're discriminating against me, and I'm leaving. And he'd leave. So then I would do a notice of intent to dismiss his case. He would object. He'd come back a month later. And we repeat this over and over to a point where I was like, what am I going to do with this man? How am I going to try his case? And eventually he just never came back. But it was really hard to deal with it, knowing every time I was going there trying to try this case, and I had this somewhat rabid defense attorney wanting to finish the trial, and we had loads and loads of records for me to just keep patient and accept the fact that if I went in there, that man would just tell me I'm discriminating against him, expect the fact that he'll just leave, and that'll be the end of the case, and eventually one day he won't come back. And that really is what happened.
Elena, you're next.
I had a case down in South County, and there was a transgender client who had been arrested, and they had taken her and placed her in the men's jail for holding, taken her wig. And when she was in court, down in Santa Clara County, they put all of the defendants in the jury box, and they're chained together. And the judge continued to call that client Sir and Mr. And refer to her as him. And every time the judge did, I corrected it. And he continued to do it, and I corrected it. And I think in situations like that, again, you don't let it pass, you be respectful, and you keep making your point over and over again that everybody deserves dignity and respect when they walk into the courtroom.
Mark.
Yeah. About 3 years ago, my partner and I were in trial in a really challenging case in San Francisco. We represented someone who worked in the city attorney's office. She discovered fraud in the unit and connected to very politically powerful people in San Francisco, and she was fired for it. And so we went to trial, and the city and county of San Francisco hired one of the most famous law firms and lawyers out there. That lawyer routinely would walk by my client, a well-known attorney named Joanne Hepper, and call her asshole in court. This was 3 years ago. He'd walk by me and call me idiot. He would call my law partner stupid. This was just like he'd walk by and be like, idiot. Very famous, well-known lawyer. And the way I dealt with it is I went out there, we tried our case, we won it, we got a $6 million judgment, and I think it's going to be affirmed on appeal as a result of the Court of Appeals argument we had the other day. But at the end of the day, rather than confront a famous person who had no sense of himself, I thought the best way to handle myself and for my client was for us to rise above that and not even dignify it with a response because it wasn't worthy of mine.
Thank you.
Next question. Other than budgetary concerns, what are the biggest challenges facing the Alameda court system, and what would you propose to address if you were to be the PJ tomorrow? And we're going to start with Elena.
I think, as I touched on briefly, is the lack of regional courts. Because, if you live in Albany, if you live in Livermore, and you need a restraining order, you've got to get yourself to Hayward. If you're relying on public transportation, you have to get then from the BART station, you have to get a shuttle, and you have to get to court. The other thing that I think is important to get going is the pretrial services and the mental health diversions. Those things have been essentially put in place, but nothing is happening with them. So I would do everything I could to get the pretrial services going so people can be released without posting a bail, and also to do something about the mental health diversion so that there is clear rules for everyone. You know what's going to happen, you know what the client needs, and that it is available for those people who need it, so that the jails aren't the place to house mentally ill people.
Lilith.
I think one of the things that the Superior Court system could learn from my system is how to streamline cases, right? People know in my system, we go in, we go out, and we're done with our trials. Longest trial I did was maybe 4 days long, and they were complex trials, so it's not like I do really easy little trials. Some of them are, but they were complex trials. And I think one thing that the Superior Court system could really focus on is streamlining the cases, so you're making better use of the judges that are there. Because if the judges are not sitting in trial for several weeks, then you can use them and maybe create court systems like Elena is referring to, where you can go maybe to a different area to sign those orders for restraining orders in the neighborhoods that doesn't have the actual regional court present. You could literally have just a building with an office where a judge could do that. Mark.
You know, there are so many different barriers to access right now in the court system, and that's just, as a litigant, it's a frustrating thing. You know, for example, I think I sit occasionally as a judge pro tem, and I was doing traffic court in Fremont. And for example, I mean, you had to wait for Punjabi interpreters to come and Hmong language interpreters. And, you know, and I think that's related to the resource question, but at the same time, I think our system hasn't quite grown to realize the entire diversity that we see here in Alameda County. And so I think what we need to do is to put resources into really kind of fully completing that picture by devoting more resources to things like various foreign language interpreters. And then the other thing I see that's really a barrier to access is that our clerk's hours seem to get shorter and shorter and shorter. And so if you don't get to a civil filing window, I think by 2 o'clock, like, your thing just ain't gonna get filed. And that's really burdensome, particularly again if you're a self-represented party or if you're in a small law firm and can't sort of afford to camp out for 2 hours and hope your thing gets filed or not.
The next question is this: do you think a judge should act or behave differently when dealing with an unrepresented litigant as compared to dealing with a lawyer? And if so, how? Lilith.
You act differently only in the sense that you want to make sure that the person who's not represented, their constitutional rights are still protected, right? But at the same time, the person who's paying for a lawyer to be present, you can't litigate for the person who's unrepresented, right? You cannot become their lawyer. And this is something that I deal with day in and day out, where on the one hand, I want to make sure that the person who's in front of me is getting what they need out of the system, but on the other hand, the person who's paying for the representation isn't paying more money because suddenly someone doesn't have representation. So I really do think it's a fine balance, and it's something that you just learn over time, dealing with people, presiding over cases where you have represented and unrepresented parties, and I've got extreme amounts of experience in that. I deal with it at least several times a week.
Mark.
I think kind of in a certain level, no. I think that what we want are judges who treat everybody with basic human dignity, decency, and a sense of empathy and compassion. I think that you have to pay special attention to people who are self-represented because they don't know their way around the legal system. But I know, for example, when I'm in Los Angeles, for example, I see judges who seem to take a lot of pleasure in just being mean and unkind to attorneys for no other reason than they seem to get enjoyment out of it, and sometimes they seem to be fine with self-represented litigants. And I don't know what motivates that, I can't speak to it, but I think the bottom line is what we're supposed to do as judges is to treat everyone with fairness, dignity, empathy, and compassion, and I don't think that should change whether the person appearing before us is a lawyer or not.
Elena.
I believe that you should treat them the same, both the non-represented litigant and the litigant that has a lawyer. 50% of people who come into the courtroom outside of criminal come in without a lawyer because they can't afford one. So they don't need to be treated differently, but they need the time and the respect to hear and to ask questions to make sure they understand what's happening, to make sure they understand what's going on, and to make sure that they are doing what they intend to do, and that they have the space and the time to do that. Not to treat them differently, but to make sure that they have their day in court as best as they can.
Next question. Have you ever been involved in a case in which you felt another attorney should be sanctioned? Tell us about it, obviously, without saying who the other attorney is. Mark.
Beyond sort of the typical discovery disputes where I think we as litigants get very frustrated with sometimes, particularly when you're fighting large corporations, and they'll sort of jerk you around in discovery. You'll go through all the work to bring a motion to compel. You get into a courtroom and a judge says, why don't you all work it out? Go outside, go work it out, and come back and see me. And, there are times where you're like, no, this is just downright sanctionable conduct, and it should be. And in personal experience, I did have the good fortune once. I represented a mentally ill elderly woman who was abused in a skilled nursing facility in an elder abuse home. And after pushing and pushing and pushing, we actually got a judge to sanction the other side and issue sanctions and evidentiary sanctions at trial for repeated abuses of the discovery process. And I think that, frankly, we need more of that rather than less of us for those who are fighting in the civil arena, because, frankly, the large and the powerful can get away with murder when it comes to discovery, which is the bane of what we do in civil litigation, and often they don't pay any price for that misuse.
Elena.
I have had attorneys, opposing counsel, bring up issues in trial that are clearly outside of the rules of evidence because they want to gain an advantage in front of the jury to the detriment of my clients. And for my clients, that means their liberty is at stake. So I do think that sanctions are appropriate when it's a clear, knowing violation of the law.
I have actually sanctioned people, but most of the time when I issue an order of sanction, it's because someone has lied to me for one reason or another. Misrepresenting cases and what they stand for is not telling the truth to the judge. Misrepresenting the facts of the case, which happens more frequently than you could ever imagine, is not appropriate, and I do sanction parties for that. And I have actually sanctioned attorneys for misbehaving, calling someone a name in a courtroom that was not appropriate. So I have wielded my power of sanction on a regular basis. I don't like doing it because I don't like people coming into my courtroom thinking that every time they open their mouth, the sanction order will be thrown against them. But there are certain times where it cannot be accepted. People cannot lie, they cannot misrepresent things, and if you catch them on it, you absolutely must sanction them.
This is our last question.
Until we do the audience part in it.
Last question from us. What distinguishes you from your opponents for this seat? And let's start with Lila.
As I already said, I'm a judge. I've got 15 years of trying cases. I've got 15 years of not representing someone, but knowing how to listen to two sides and decide based on what was given to me. That's my biggest experience. The ability to know how to handle unrepresented people certainly is an important part in family courts. I have that experience. I know how to talk to people who do not have lawyers. Elena has great experience representing people who need representation that may not have an educational level, that jives with the rest of the courtroom, and she knows how to talk to them. But as a judge, I have worked with people and tried people's cases who do not have lawyers. I know how to start them, I know how to finish them, and I know how to do it without wasting any court time. My calendar docket is referred to as the I forget the name of it now, but I work my calendar so fast that when I've had two last names for a period of time, I got double set for two different judges' calendars, and I still finish my cases.
The rocket docket?
That's what they call it. Thank you. The rocket docket, that's what they call it.
Elena,
I'm sorry, the question again?
what distinguishes you from your opponents?
Oh, well, my 26 years in the Alameda County courts, I think, distinguishes me from my opponents. I have been in the courts, I've been working in the courts, I've been working with the people and the judges in Alameda County, which is how I have earned the endorsements. I also have diversity. 81% of the judges in Alameda County come from civil or prosecution side. As a private defender, I bring a perspective to the bench that I think there's only one or two or three judges who have it. I am also a Latina, and there have only been two on the bench at a time. And so I bring diversity, I bring experience, and I bring integrity to the bench, and I think that's what distinguishes me from the other two.
Thank you, Mark.
I think what distinguishes me is my diversity of experience and the diversity I would bring as a gay man. I too am in the courts every day, not just here in Alameda County, but in Washington State, Oregon State, and all over the place. And so I've had the opportunity to see what I like from judges and juries and practitioners, not just here in Alameda County, but in several counties. I think the fact that I've done criminal and civil cases, both on the prosecution and the defense side for much of my career, distinguishes me. I think that I've tried 50 cases to verdict distinguishes me. And lastly, I think my deep commitment to the community and the people of Alameda County is what distinguishes me. I've been deeply involved in the LGBTQ movement. I've been deeply involved in the synagogue movement. I've been deeply involved with communities of faith, helping to feed the hungry and clothe the poor in Alameda County. And I think it's that diversity of life experience and diversity of legal experience that has earned me the endorsement of the California Democratic Party, the Asian Pacific American Democratic Caucus, and more than 20 elected leaders throughout Alameda County.
Thank you.
So now we're going to enter the questions from the audience portion of our program. Are there any questions from any members of the audience? Go ahead.
Looking back through history, which judge do you most admire? And what will you do to emulate that one you
We'll start with Elena.
Can you just repeat the question?
Oh, sure. The question was, looking back into history, what judge do you most admire and how will you emulate them in your judgeship? And we will start with Elena.
I have two. The first one is Judge Carol Brosnahan, because I have been in front of Judge Brosnahan for my entire career. And what I learned from her is that every single person who comes into her court is given respect and dignity and honor for who they are, wherever they are. She has some of the most difficult people in this county coming to her courtroom, and every single one of them comes away from her courtroom knowing that they are noticed and recognized for who they are, where they are. And Sonia Sotomayor, because she brings her life experience as a Latina and can share that with the rest of the court, because they don't have that life experience. And so I also admire her.
Mark.
I guess I'm going to pick two as well. I'd say just because of a unique moment in time, actually, Justice Anthony Kennedy, who spent most of his career being viewed as a conservative, but was really the lead author of the Obergefell decision. And it was Justice Kennedy who came from a conservative Republican background who had the courage to legalize marriage for all of us. And it's because of Justice Kennedy that my husband and I, after being parents for many years, could actually marry, and our children could legally consider us both their parents. And it was Justice Kennedy's opinion in Obergefell to recognize the inherent dignity in all people and all human relationships. That is something I think I would always emulate. And I think I would also add to that Judge Vaughn Walker is really one of the first openly gay federal judges in the area. And so I'd like to carry on that legacy of being one of the very few openly gay men to serve on the bench.
Lila.
I have a puppy, and my puppy's name is Ruth Bader Ginsburg. She's my hero. When I went to watch her documentary, I walked out of there with my boys in tears, not because I was crying over her, because they looked at me and said, "Mom, that's you." And I'm like, no, I'm not Ruth Bader Ginsburg. But since they picked two, there is one other person, and that would be my presiding judge. He is the best judge I have ever seen. He never loses his temper. He is fair, even though I think he's a little too conservative for my taste. He has guided me over the years, not just to be a good judge, but to help me become the presiding judge once he leaves office. And he's been the most supportive person for me for running this position, even though I go in there every day, I'm like, I'm never going to win this, why am I here? But he has been there to guide me in my writing. He's been there to guide me in my temperament, which has needed some help, and he was very good at training me on that. But he's just given me a lot of love, and that's what he gives in his courtroom, and that's what I hope to be.
Please.
Yes, I'd like to ask the panel, we recently had a very difficult case in Alameda County, which was the Moms for Housing case. And that ended up in an injunction, and some serious repercussions on how the sheriff reacted afterwards. I'd like to ask the three of you how you would have ruled in that case, and why, and if there was anything you would have done in your order to perhaps prevent the aftermath of how that decision was carried out.
We really actually shouldn't talk about that because that is something that we would be faced at potentially as judges. So I really don't think it'd be appropriate for us to respond to that question. Right, so we should.
Is it over?
It is not, as far as I know. I mean, I think they're coming to some terms, but just in case, we probably shouldn't ask any questions that have to do with cases that are pending, or pretty close to being pending, or that are current in front of any particular member of the audience that might be watching this, right? Like, so, anyway, just
Can I
to be
leave
safe.
it to then just how would you handle your order in a case like that where you're worried about how it will, any case that you would have, if you have
So-
some concern about.
Maybe I can rephrase the question.
Thank you.
Obviously, as members of the judiciary, you will be facing cases that will get a lot of news coverage, perhaps, maybe a lot of indignation from one side or the other. You know, things are controversial sometimes. How would you, in the face of that controversy, keep a level head and do what you need to do in your position as judge? And then let's start with Mark.
You know, I think raising two teenagers has helped me try to keep a level head, as has trying to keep an active meditation practice. But look, ultimately that's the job, is we have to do our best to try to be fair and thoughtful and deliberative. And I've seen judges do this where things are just getting so hot in a courtroom, they just say, I'm going to take a recess, I'm going to leave right now, so that I as a judge can actually do my function properly without getting into it with the litigants, because we've all seen that when judges are tearing their hair out and how difficult that can be. I think extending it to what maybe Rena was getting at, though, I think sometimes we know our decisions could have tremendous public impact, and I think where public safety is an issue and things like that, we have to be very mindful about how our orders will be carried out, and we should be mindful of trying to build into the orders we write ways to do our best to minimize negative public safety impacts.
I guess I heard a different question to what Mark responded to, which I heard the question of how would I deal with if we did have a lot of media attention in the courtroom, how would I deal with the media attention itself? Am I misunderstanding your question? Well, I think that's pretty broad, right? Okay. So it can be, how would you deal with the media attention? How would you deal with the fact that you know that there is going to be a lot of potential backlash, and you know, maybe judges may have the fear of making decisions that may be unpopular or against public sentiment and things like that. So how would you deal with that situation? I have been on those situations before. There's a lot of cases in the workers' compensation system that do actually get a lot of public attention. You still have to just remember that it's just any other case, okay? Just because it's getting the attention of the public doesn't mean you treat it any differently. You still have to put it through the process exactly the same way you would put any other case through the process, even if you have people in there with video cameras videotaping the hearing, right? So I usually just take my cases, as I said before, as they come in front of me, just apply the facts and come out with whatever the ruling is based on what the law is. You can't write a decision just to appease the public because you may be running for election. You can't write a decision because you might hurt someone else's feeling if that's the correct decision to make. You can't write a decision because that's what you think it should be, but that's not what the law is. You can sort of work around it, but sometimes you will have to make decisions that you may not like just because that is what the law is. Elena.
Yeah, I agree. You have to follow the law, you have to make a decision on what's right, regardless of the consequences. And I can't imagine the judge thought that the sheriff would show up with a tank when he entered that decision. So so what happens outside of the courtroom should have nothing to do with what happens inside the courtroom. The case that's before the judge should be decided on its merits. The decision should be on its merits, regardless of what the consequences are, regardless of what the people outside the courtroom feel about it. I'm a criminal defense attorney. My middle name is unpopular. So I am used to doing things that people don't like. But that is the nature of the work.
Do we other, yes, please.
What was your most significant trial of the last 5 years and why? And was it bench or jury? A little bit about it.
Lila, will you start, please?
Sure. I think the most significant case I've tried that had to do with an undercover deputy county sheriff who on New Year's Eve was driving home and was killed in a single car accident. He left behind a widow, and the county of Alameda denied the case, said they didn't have coverage on that case because the county sheriff was intoxicated. He was intoxicated, but he was working undercover. Undercover police officers cannot go to a drug community and say, oh, I can't have a drink today because I have to drive home, right? He was so undercover that even the county didn't know exactly where he was, so a lot of the people came to testify about exactly where he was and what he was doing that knew where he was. And that case just stayed with me all this time because I managed to find in favor of the widow so she could get the money. But it was after she lost her house and she was pregnant when he died. So I have never forgotten that case.
Alina?
My most significant trial for me was a client that I had. He was a gay man who got in a fight with his neighbor, and he had a reasonable offer. The problem was that offer would have gotten him deported. And so to get through the trial and to get a verdict that to get a not guilty verdict for him so that he would not suffer the consequences of deportation, it was the right result given the circumstances, but it was risky, and in that case it allowed him to keep his family together, it allowed him to stay with his partner, and he didn't have to suffer the consequences. So being able to present to a jury, because you can't mention that kind of thing with a jury, but being able to present to a jury his story and making him a human being and making him someone deserving of a not guilty verdict, I think was the most significant thing.
Mark?
Yeah, the trial I'm most proud of in the past 5 years is local Berkeley hero Joanne Hepper, who had the courage after discovering that the city attorney office had honored $20 million in fraudulent sewer claims, went to Dennis Herrera and said there's fraud in the office, and because that fraud implicated a friend of Mr. Herrera who was very politically prominent in the Democratic Party, she lost her job for it. And she had to take that case to trial and go against John Kecker of Kecker and Van Ness, one of the biggest and most famous law firms in the city. She had to undergo constant humiliation and mistreatment by Mr. Kecker and his staff in that courtroom, and she had to stand tall, and she's had to continue to stand tall for the past 3 years. And again, we had oral argument this week, which was very encouraging, and they tried to silence her at every turn, saying she was a lawyer, so she had no right to speak. Of course, they trashed her in the press, which is why the attorney-client privilege was waived, and she was able to pursue her claims. But my ability, I take great pride and joy in representing someone who's a true hero and a whistleblower, and having taken that case to verdict and won.
Question in the back.
So I've reviewed all of your qualifications, and it seems like you all have pros and cons. What do you see as based on your experience, your biggest challenge to sitting on the bench in Alameda County, and how would you deal with that?
Let's start with Elena?
I would say that the biggest challenge for me in being on the bench in Alameda County, quite frankly, would be going to the same place every day. I'm in private practice. I'm in courtrooms all over the place, all over Alameda County, all over Northern California. And I think going to the same place every day is going to be my biggest challenge.
Mark?
I think for me, the biggest challenge is the somewhat isolating nature of being a judge. I mean, what makes my firm such a special place is that my partners and I, we get together all the time and we talk about this case. How are we going to do that? How are we going to handle that problem? How are we going to make this lawyer that works for us a better attorney? You know, we do a lot of mentoring and we just do a lot of talking to grow professionally and to help the people who work with us grow. When you're a judge, it's not so easy to go to the next door and go, hey there, how do I get to be a better judge? Or how do I write this summary judgment order better? I think you have to start to kind of work on your own, and you tend to learn when someone tells you you've done something wrong, right? And someone calls you out for something and then kind of scolded about how you didn't handle that as well. And I think that sort of inherently more isolating nature of being a judge would be something that would take a while for me to get used to.
Lila?
These guys really like standing up, so I'm gonna stand up. Lawyers are like in church, constantly sit down, stand up, sit down, stand up. All right, I'll stand up. For me, I think the biggest challenge for me would be to learn whatever court I am in, to learn the law that I'm having to apply, right? I haven't done criminal work, although I've had the unfortunate experience of one of my sons dragging me into a criminal court, so I got a law experience there. I haven't done family law, but I've been divorced many times, so I know what to do there. No one's died yet, so I haven't been in trust in estates. But I think that'll be my biggest challenge, is really to learn the area of the law that they send me to have to deal with. And every time you go through rotation, it's something you have to learn. But I learned to teach yoga when I was over 50, and I managed to do that, and I'm a certified yoga instructor, so if I can do that, I can do anything.
Very good. Audience, any more?
So let's go to the closing statements, but before we do that, I've been asked to move this so that people can see the speakers more. So let me try. Right now what they can see is my face, so that's not really the point. All right. What order are we doing the closing statements in, boss?
We'll just keep rotating.
Okay, so where are we?
We're going to start with Mark, and then go to Lila, and go to Elena.
All righty.
Closing statement.
All right, and I've lost track of the different time limits. So
2 minutes.
2 minutes.
2 minutes. All right. Thank you, everyone, for having me here tonight. It's been a pleasure to get to talk to a room of lawyers about some of their concerns and issues here. I think that I would add diversity to the bench. Again, I would be only the second openly gay man to serve on the bench. But beyond the diversity that one brings by way of sexual orientation or anything else for that matter, I believe I bring a diversity of experience to the bench. And that's not just legal experience, that's life experience. My husband and I have raised 2 twins. We've had our own experiences with the legal system in terms of becoming parents, in terms of getting both names on a birth certificate, in terms of dealing with all those complexities. And I believe that it's a function of life experience. You know, I grew up and I knew what it was like to be called a fag or to be called a kike growing up in San Francisco. It wasn't so not long ago that people got called those kinds of names. And I think that I've always carried with me, my grandparents being Holocaust survivors always gave me this notion that you have to give back to the community that's blessed you so much. I've been a resident of Alameda County since 1987 when I came here to go to Berkeley. This place has been my home except for a 5-year stint. I've raised my children here. I've been on the PTA here. I've helped feed the homeless here. And I've been involved in every corner of this community. And so it's very humbling to appear before the voters of all of Alameda County. But I would ask you to consider voting for me and for supporting me because I believe in the people of Alameda County. And I believe that I would truly be a good judge and the best judge for the people of this county. Thank you so much for your time.
All of us have some level of minority status about us, right? I'm an immigrant. A Elena is Latina. Then there is the sexual orientation that also comes into play. So when you look at the three of us, we all have some level of minority status about us. We all have experience. So how do you choose someone when you have such a diverse group in front of you for your next judge? Well, I look at this way. If you were going to hire a bus driver, right? And you have three people that all drive a car. Elena is driving her Yugo. Mark is driving his Mercedes. I'm already a bus driver, all right? Elena drives on one street. Mark drives on many different streets. And then I'm just driving a big bus. I may not drive the streets Elena has driven down on, and I may have driven some of the streets Mark has driven down on, but I know how to drive the big bus. And they don't, because she's still driving her Yugo and he's driving his Mercedes. So who are you going to hire? You're going to hire the person that's driving the big bus, right? Because they have the experience. That's the best way to decide it. Thank you. Well, the Yugo is offended.
Mercedes, I'm offended by.
I'm sorry. Oh, that's right. I didn't think about that. Sorry. Could have given you a different card.
I was born and raised in Arizona. I know how to drive a pickup, so I can drive a bus. I have been working in Alameda County for 26 years. I have been in the courts for 26 years. And that has earned me the endorsements of 27 of the sitting judges, a couple of judges in Contra Costa County, because they know me, and they know my work, and they know my integrity, and my commitment to justice. I have also been in this community for 29 years. My daughter went to public schools. I volunteered at the schools. And professionally, I've been a member of Women Defenders. I've been a co-chair of Women Defenders, and that is where we have showcased women in the criminal defense area so that they can be seen as experts in what was used to be a completely male-dominated field. I've been a board member of the East Bay La Raza Lawyers Association for 20 years, and we have been building up the pipeline of young Latino lawyers to come up through the ranks, and so that it is not an anomaly to see a Latino in the courtroom and mistake them for something else. So that when there's a Latino in the courtroom, the first association is that they're the lawyer. So I have been doing the hard work in Alameda County of opening access to the courts, bringing up diversity in the courts. Alameda County has 51% women. A woman is stepping down, and I think I am the woman who should take her place. I bring experience of the law, experience of the county, and a commitment to justice for everyone. And I hope that when you have an opportunity to vote, that you vote for me. Thank you.
Okay.
All right, so thank you very much for being here. Please join me in thanking our candidates. And our questioners, Alice and Peter, excellent job. And also, of course, the League of Women Voters. So I'm going to ask you to give them a moment to go into the other room. And as a reminder, we're not leaving through this door. We're going to leave through that door so you can have a chance to speak to them and get their materials and all like that. So thanks again. We really appreciate your being here. Have a great night.
Thank you.